Thank you, Mr. Chairman, ranking member, other distinguished members of the committee. It's an honor and a privilege to join the other distinguished witnesses to discuss a matter of grave concern to our country and to our Constitution. Because this House, the People's House, has the sole power of impeachment, there is no better forum to discuss the constitutional standard for impeachment and whether that standard has been met in the case of the current President of the United States. As I explain in the remainder and balance of my opening statement, the record compiled thus far shows the President has committed several impeachable offenses, including bribery, abuse of power, and soliciting a personal favor from a foreign leader to benefit himself personally, obstructing justice, and obstructing Congress. Our hearing today should serve as a reminder of one of the fundamental principles that drove the founders of our Constitution to break from England and to draft their own Constitution. The principle that in this country, no one is king. We have followed that principle since before the founding of the Constitution, and it is recognized around the world as a fixed, inspiring American ideal. In his third message to Congress in 1903, President Theodore Roosevelt delivered one of the finest articulations of this principle. He said, "No one is above the law and no man is below, nor do we ask any man's permission when we require him to obey it. Obedience to the law is demanded as a right, not asked for as a favor." Three features of our Constitution protect the fundamental principle that no one, not even the President, is above the law. First, in the British system, the public had no choice over the monarch who ruled them. In our Constitution, the framers allowed elections to serve as a crucial means for ensuring presidential accountability. Second, in the British system, the king could do no wrong, and no other parts of the government could check his misconduct. In our Constitution, the framers developed the concept of separation of powers, which consists of checks and balances designed to prevent any branch, including the presidency, from becoming tyrannical. Third, in the British system, everyone but the king was impeachable. Our framers' generation pledged their lives and fortunes to rebel against a monarch whom they saw as corrupt, tyrannical, and entitled to do no wrong. In our Declaration of Independence, the framers set forth a series of impeachable offenses that the king had committed against the American colonists. When the framers later convened in Philadelphia to draft our Constitution, they were united around a simple, indisputable principle that was a major safeguard for the public: we the people, against tyranny of any kind. A people who had overthrown a king were not going to turn around just after securing their independence from corrupt monarchical tyranny and create an office that, like the king, was above the law and could do no wrong. The framers created a chief executive to bring energy to the administration of federal laws, but to be accountable to Congress for treason, bribery, or other high crimes and misdemeanors. The framers' concern about the need to protect against a corrupt president was evident throughout the convention. And here, I must thank my prior two friends who have spoken and referred to a North Carolinian, William Davey. I will refer to another North Carolinian in the Constitutional Convention. James Iredell, whom President Washington later appointed to the Supreme Court, assured his fellow delegates, the president, quote, is of a very different nature from a monarch. He is to be personally responsible for any abuse of the great trust placed in him, unquote. This brings us, of course, to the crucial question we're here to talk about today, the standard for impeachment. The Constitution defines treason, and the term bribery basically means using office for personal gain, or I should say misusing office for personal gain. And as Professor Feldman pointed out, these terms derive from the British, who understood the class of cases that would be impeachable to refer to political crimes, which included great offenses against the United States, attempts to subvert the Constitution, when the president deviates from his duty or dares to abuse the power invested in him by the people, breaches of the public trust, and serious injuries to the Republic. In his influential essay in the Federalist Papers, Alexander Hamilton declared that impeachable offenses are those offenses which proceed from the misconduct of public men, or in other words, the abuse or violation of some public trust, and relate chiefly to injuries done immediately to the society itself. Several themes emerge from the framers' discussion of the scope of impeachable offenses and impeachment practice. We know that not all impeachable offenses are criminal, and we know that not all felonies are impeachable offenses. We know further that what matters in determining whether particular misconduct constitutes a high crime and misdemeanor is ultimately the context and the gravity of the misconduct in question. After reviewing the evidence that's been made public, I cannot help but conclude that this president has attacked each of the Constitution's safeguards against establishing a monarchy in this country. Both the context and gravity of the president's misconduct are clear. The favor he requested from Ukraine's president was to receive, in exchange for his use of presidential power, Ukraine's announcement of a criminal investigation of a political rival. The investigation was not the important action for the president. The announcement was, because it could then be used in this country to manipulate the public into casting aside the president's political rival because of concerns about his corruption. The gravity of the president's misconduct is apparent when we compare it to the misconduct of the one president who resigned from office to avoid impeachment, conviction, and removal. The House Judiciary Committee in 1974 approved 3 articles of impeachment against Richard Nixon, who resigned a few days later. The first article charged him with obstruction of justice. If you read the Mueller report, it identifies a number of facts, I won't lay them out here right now, that suggest the president himself has obstructed justice. If we look at the second article of impeachment approved against Richard Nixon, it charged him with abuse of power for ordering the heads of the FBI, IRS, and CIA to harass his political enemies. In the present circumstance, the president has engaged in a pattern of abusing the trust placed in him by the American people by soliciting foreign countries, including China, Russia, and Ukraine, to investigate his political opponents and interfere on his behalf in elections in which he is a candidate. The third article approved against President Nixon charged that he had failed to comply with 4 legislative subpoenas. In the present circumstance, the president has refused to comply with and directed at least 10 others in his administration not to comply with lawful congressional subpoenas, including Secretary of State Mike Pompeo, Energy Secretary Rick Perry, and Acting Chief of Staff and Head of the Office of Management and Budget, Mick Mulvaney. As Senator Lindsey Graham, now chair of the Senate Judiciary Committee, said when he was a member of the House on the verge of impeaching President Clinton, the day Richard Nixon failed to answer that subpoena is the day he was subject to impeachment because he took the power from Congress, over the impeachment process away from Congress, and he became the judge and jury. That is a perfectly good articulation of why obstruction of Congress is impeachable. The president's defiance of Congress is all the more troubling due to the rationale he claims for his obstruction. His arguments and those of his subordinates, including his White House counsel, in his October 8th letter to the Speaker and 3 committee chairs, boils down to the assertion that he is above the law. I won't reread that letter here, but I do want to disagree with the characterization in the letter of these proceedings, since the Constitution expressly says, and the Supreme Court has unanimously affirmed, that the House has the sole power of impeachment, and like the Senate, the House has the power to determine the rules for its proceedings. The president and his subordinates have argued further that the president is entitled to absolute immunity from criminal procedure, even an investigation for any criminal wrongdoing, including shooting someone on Fifth Avenue. The president has claimed further he's entitled to absolute executive privilege, not to share any information he doesn't want to share with another branch. He's also claimed the entitlement to be able to order the executive branch, as he's done, not to cooperate with this body when it conducts an investigation of the president. If left unchecked, the president will likely continue his pattern of soliciting foreign interference on behalf of the next election, and of course, his obstruction of Congress. The fact that we can easily transpose the articles of impeachment against President Nixon onto the actions of this president speaks volumes. And that does not even include the most serious national security concerns and election interference concerns at the heart of this president's misconduct. No misconduct is more antithetical to our democracy, and nothing injures the American people more than a president who uses his power to weaken their authority under the Constitution, as well as the authority of the Constitution itself. May I read one more sentence, or, I'm sorry.
The witness may have another sentence or two.
Thank you. If Congress fails to impeach here, then the impeachment process has lost all meaning. And along with that, our Constitution's carefully crafted safeguards against the establishment of a king on American soil. And therefore, I stand with the Constitution, and I stand with the framers who were committed to ensure that no one is above the law.